Kia ora and welcome back to the HRPI. I'm Marie Tovio, Employment Relations Consultant, Private Investigator, and your guide to navigating New Zealand's trickier workplace situations. Today's case file is the Contractor Conundrum, when someone is engaged as an independent contractor, but the question arises, are they really a contractor? This has always been an important issue for New Zealand businesses. And it became even more important in February 2026 when the law changed and introduced a new test for determining contractor status. So let's open the case file. Imagine a business needs some specialist support. They don't want to employ someone, so they engage a contractor instead. There's a contractor agreement. The person invoices for their services. Everyone understands that they're self-employed. So far, so good. But several years later, the arrangement looks quite different. Perhaps the contractor now works regular hours. They're closely involved with the business. They attend team meetings. They use company systems and equipment. Their work is managed by someone inside the organisation. Maybe they've gradually become almost indistinguishable from members of the employed team. Then something happens. The arrangement ends, there's a dispute, and the contractor says, "Actually, I think I was an employee." Historically, that's when things could become very interesting. Because under New Zealand employment law, simply putting the words independent contractor or similar at the top of an agreement did not determine the legal status of the relationship. The Employment Relations Authority or Employment Court could look beyond the agreement and examine what was really happening. That principle still matters. But since 21 February 2026, there's now an important first step, the new gateway test. You may have heard that the law around contractors has changed. The Employment Relations Amendment Act introduced what's known as the gateway test. In simple terms, the gateway test is designed to provide greater certainty around genuine independent contractor arrangements. Think of it as an initial checklist. If the arrangement meets all 5 requirements in the checklist, the person is treated as what the legislation calls a specified contractor. And that's significant because if all 5 requirements are met, we don't then move on to the traditional common law analysis of whether the relationship looks more like employment. So what are those 5 requirements? Let's try and put them into plain English. First, there needs to be a written agreement that makes it clear the person is an independent contractor or is not an employee. So the paperwork does matter, but as we're about to see, paperwork alone isn't enough. Second, the contractor must be allowed to work for someone else. That doesn't mean that they actually have to have several clients. They might choose to work primarily or even entirely for one business. The important point for the gateway test is that the arrangement allows them to work for others. The legislation now specifies that contractors can't be contractually prohibited from having other clients, except to the extent they're already committed to performing work for the first client at that time. Third, there needs to be genuine flexibility in how the work is arranged. The contractor must either be able to choose when they work or be able to subcontract the work to someone else. There are some limited circumstances where the person doing that subcontracted work can be vetted, for example, to make sure they hold qualifications required for the work or because a criminal record check is relevant. Fourth, if the business offers the contractor additional work, the contractor must be able to turn that work down without the entire contracting arrangement being terminated as a result. In other words, there needs to be a genuine ability to say, "No thanks, I'm not available for that piece of work." And fifth, before entering into the arrangement, the contractor must have had a reasonable opportunity to seek independent advice. If all five requirements are met, the person is a specified contractor for the purposes of the Employment Relations Act. That gives businesses and contractors considerably more certainty than they had previously. But there's an important but. If even one of those gateway requirements is not met, that doesn't automatically mean the person is an employee. Instead, we move to the second part of the analysis, and this is where the traditional legal tests come back into play. If the gateway test isn't satisfied, we ask the more familiar question, what is the real nature of this working relationship? And importantly, there isn't one single factor that gives us the answer. The courts have developed a number of tests that are considered together. One is intention. What did the parties intend the relationship to be? A properly drafted contractor agreement is relevant here, but it isn't necessarily conclusive. Then there's control and independence. Who controls how the work is carried out? Does the person largely organise their own work? Or are they being directed in much the same way as an employee? Another consideration is integration. Is this someone genuinely operating their own independent business? Or have they effectively become part and parcel of your organisation? And finally, there's what's sometimes called the fundamental or economic reality test. Stepping back and looking at the whole situation, is this person really running a business on their own account? Do they carry financial risk? Can they make a profit? Do they provide their own equipment? Do they invoice for their services? Can they engage others to perform work? Do they decide how they organise their business? Or does the economic reality look much more like employment? No one factor necessarily determines the answer. It's the overall picture that matters. Back to our case file. So, let's return to our contractor. They've been with the organisation for several years. If their arrangement meets all five elements of the gateway test, they have considerably more certainty about their status as a specified contractor. But suppose it doesn't. Perhaps their agreement prevents them from working for anyone else. Perhaps they can't choose when they work and they can't subcontract. Perhaps they're effectively required to accept every additional piece of work offered to them because declining it would jeopardise the whole arrangement. Or perhaps they weren't given a reasonable opportunity to seek independent advice before entering into the arrangement. Now we need to look at the common law tests. And that means the day-to-day reality of the relationship becomes very important. Maybe they work fixed hours determined by the business. They have little control over how their work is performed. Their work is closely supervised. They use the organisation's equipment. They've become completely integrated into the team. They carry little or no commercial risk. And economically, they look much more like a worker selling their labour to one organisation than someone genuinely operating their own independent business. Taken together, those factors could point towards an employment relationship. And this is why employers still can't assume that having a contractor agreement resolves the issue. So, what if you get it wrong? If someone has been incorrectly treated as a contractor when they should actually have been an employee, the consequences can be significant. Employees have minimum statutory rights that contractors generally don't have. Depending on the circumstances, an employer could find itself dealing with issues such as unpaid holiday and leave entitlements, minimum wage obligations, tax and PAYE consequences, KiwiSaver obligations, and other employment-related entitlements. The person may also have access to employment remedies that weren't available to them while they were being treated as a contractor, including where the legal requirements are met, the ability to raise a personal grievance. So this isn't simply an argument over terminology. It can create very real legal and financial consequences for a business. One of the things I'd particularly caution employers against is what I call the set and forget contractor arrangement. Someone's engaged as a contractor, an agreement is signed, but it's then filed away, and nobody looks at it again for the next 5 years. Meanwhile, the business changes, the work changes, and the expectations change. The relationship has changed. There is another reason to review existing arrangements now. The new gateway test only took effect on 21 February 2026, and it isn't retrospective. That means for contractor arrangements that were already in place before that date, different tests can potentially be relevant to different periods of the relationship. For the period before 21 February 2026, the common law test remains relevant. From 21 February 26 onwards, the gateway test can also apply. So if you have long-standing contractor arrangements, now is a very sensible time to review them. Another area I'd watch closely is control. There's an important distinction between engaging a contractor to deliver an agreed result and managing that person as though they're an employee. Of course, businesses can still set expectations. You can specify outcomes. You can set quality standards. You can impose legitimate health and safety requirements. You can require compliance with legal, security, privacy, or client requirements. Being a contractor doesn't mean someone can simply do whatever they like. But if the relationship falls outside the gateway test and you're determining the real nature of the relationship, a high degree of day-to-day control can become significant. If you're deciding exactly when they work, closely supervising how they perform every task, controlling their availability, and effectively managing them as a member of staff, it may be time to reconsider whether the contracting model is still the right one. So, what does good practice look like now? First, choose the right relationship from the outset. Don't decide that you want a contractor and then to try and make the paperwork fit. Start by asking, what relationship are we actually trying to create? Is this genuinely someone operating their own business and providing services to yours? Or do you actually need an employee? Second, make sure your contractor agreements have been reviewed in light of the 2026 changes. If you want the certainty provided by the gateway test, you need to understand all 5 requirements. A contractor template prepared several years ago may not necessarily address them. Third, look beyond the agreement. If the arrangement doesn't satisfy the gateway test, the common law analysis becomes relevant. So ask yourself whether the way the relationship actually operates supports contractor status. Fourth, review longer-term contractor arrangements periodically. Ask, is this still operating in the way we originally intended? And would we still be comfortable defending this as a genuine contractor relationship if it was challenged tomorrow? These are useful questions. And finally, get advice early if you're unsure. It's usually far easier to review and correct an arrangement proactively than to try to unravel years of history after a dispute has arisen. So, today's key findings are these. New Zealand now has a gateway test for contractor status. If all 5 requirements are met, the worker is a specified contractor. If even one of those requirements isn't met, that does not automatically make them an employee. Instead, you move to the common law test and consider the real nature of the relationship. The written agreement matters, but depending on which test applies, what happens in practice can matter just as much. And contractor relationships shouldn't simply be set up and forgotten. They need to remain appropriate for the way the work is actually being performed. If your business uses contractors, and particularly if you have contractors who have been working with you for some time, this is a good opportunity to review those arrangements following the 2026 law change. And if you're not sure whether an arrangement meets the new gateway test, or whether the reality of the relationship still supports contractor status, that's something I can help with. I can review existing arrangements, assess the potential risk, and help businesses determine whether their contractor structures and documentation remain fit for purpose. The information in this podcast is provided as a general overview of key New Zealand employment topics and does not replace tailored advice to your particular circumstances. Employment status can depend on the specific facts of the working relationship, and the appropriate approach may vary from one situation to another. If you're unsure about the status of someone working in your business or how the new contractor test applies to an existing or proposed arrangement, I encourage you to seek advice. Feel free to reach out to me directly. The agreement examined, the relationship tested, and another reminder that in HR, the detail really does matter. Mā te wā.